Peter Thiel called Britain's attachment to the National Health Service Stockholm Syndrome. He said the system should be ripped up and started again. His company now supplies the platform where identifiable NHS patient information is stored and processed. The NHS says access is controlled and audited. Its own privacy notice also says authorised Palantir staff may process identifiable data for technical support. Both statements can be true. The question is what we have actually been asked to trust. This is not an allegation that somebody has been caught stealing patient records. It is an investigation into a powerful supplier, a sensitive public system, an access arrangement that was not properly disclosed, and a contract decision approaching in 2027. First, the platform. The Federated Data Platform is not one giant replacement for every patient's complete medical record. It connects or copies information from existing NHS systems into approved local and national environments. Hospitals and health bodies use those environments for waiting list management, discharge coordination, vaccination, supply planning and other approved work. Some information is aggregated or de-identified. Other products require directly identifiable patient details. An NHS privacy notice for its shared patient tracking product lists names, addresses, telephone numbers, dates of birth, NHS or hospital numbers, diagnoses, and treatment information. It names Palantir Technologies UK Limited as a data processor. The legal distinction matters. NHS organisations are the controllers. They decide why the data is used. Palantir is a processor acting on their instructions. That does not give Palantir ownership of your records, but it also does not mean its staff are technically incapable of seeing data in every circumstance. The contract bars Palantir from selling NHS patient data, using it for its own commercial purposes, or training its own models on it. NHS England says access is role-based, purpose-limited, approved and audited. Those are genuine protections. They are not the same as a technological guarantee of zero access. Palantir-led consortium won the NHS contract in November 2023, and the service formally began in March 2024. The number most often quoted is £330 million. That number needs careful handling. £330 million is forecast consumption over a maximum 7-year term. It is not an upfront payment, and it is not guaranteed expenditure. The public notice records an initial award period worth approximately £182 million. A wider projected lifetime cost of £1.1 billion was reported in August 2026 that covers the broader programme, including NHS deployment and implementation. It must not be presented as money all paid to Palantir. The initial contract period approaches its decision point in early 2027. Now to the central problem. A supplier can be legally restricted from using data for its own purposes, while still holding a privileged technical role that can expose identifiable information during approved support. Contractual permission and technical capability are different questions. In May 2026, reporting revealed an internal NHS briefing describing a non-NHS administrator role with unlimited access to identifiable patient information inside a national integration environment. Unlimited described the breadth of that technical role. It did not give anyone unlimited legal permission to browse or reuse data. NHS England said staff assigned such access would need security clearance, high-level approval and auditing. Palantir said unauthorised use would be unlawful and controlled. Those responses belong in the story, but they describe safeguards around access, not proof that access never exists. NHS England's own National Integration Privacy Notice, updated in June 2026, says Palantir staff may process personal data, including directly identifiable data, in some circumstances, when required for operation, maintenance, or technical support. That is the accurate finding. Authorised supplier access can exist. It is supposed to be controlled. The evidence reviewed here does not establish that Palantir employees misused patient information. The issue is whether the controls are visible, independently tested and accurately explained to the public. The transparency failure goes beyond criticism from campaigners. On 3 June 2026, National Data Guardian Dr. Nicola Bein published a statement about the access arrangements and what her office had originally been told. She said the privacy impact assessment reviewed by her office described access to identifiable information as limited to NHS staff with a legitimate need. Her office had not been told that some outside contractors could also access it. That matters because privacy assessments are supposed to identify material risks before sensitive processing expands. If a privileged contractor pathway was omitted, the public and an independent guardian were not working from the same description of the system. Can patients simply opt out? Not through the National Data Opt-out for the platform's current uses. That scheme applies to certain secondary uses, including research and planning. NHS England classifies current platform products as care delivery and service operation. The National Data Guardian confirms that position. It can be lawful. It also means telling worried patients to just opt out is not a real answer. If there is no simple individual exit, transparency, independent oversight and effective remedies become more important, not less. Do we already have the right laws? Britain has substantial data protection law. The real question is whether those laws require the right technical architecture for a strategically important national health system. Health information is special category data under UK GDPR. Processing needs a valid lawful basis and an additional condition for sensitive health data. General rules also require fairness, transparency, purpose limitation, security and accountability. Article 28 requires a processor to act on the controller's documented instructions. That means an NHS body can lawfully instruct a supplier engineer to enter a live environment for necessary support. The same engineer could act unlawfully by going beyond that instruction. Section 170 of the Data Protection Act can criminalise knowingly or recklessly obtaining or disclosing personal information without the controller's consent, subject to statutory defences. The common law duty of confidentiality also protects confidential patient information. High-risk processing should be assessed through a data protection impact assessment. Caldecott principles reinforce need-to-know access and accountability in healthcare, but neither an impact assessment nor a principle protects the public if an important access arrangement is left out. Here is the distinction that keeps disappearing. The law can forbid misuse without making misuse technologically impossible. Current rules regulate permission, purpose, necessity and security. They do not automatically require a system in which the contractor can never technically view identifiable data. A stronger legal model could start with named, just-in-time privileged access. No permanent supplier-administrator account. Each session attached to a specific person, a defined task and an automatic expiry. A second safeguard would require 2 independent NHS authorisations before a contractor sees identifiable information. An emergency process could exist, but it should be documented, time-limited and independently reviewed. Third, encryption keys should be controlled by the NHS or an independent public body, so a supplier cannot decrypt identifiable information without a public authority approval step. That converts a promise into a technical boundary. Fourth, privileged sessions should generate tamper-evident logs visible to an independent auditor. Public should receive regular, anonymised figures showing how many sessions took place, which suppliers used them, and how long they lasted. Fifth, a material change to the access model should trigger prompt publication and an updated impact assessment. It should not take a leaked briefing or a newspaper investigation to reveal a new contractor pathway. Finally, patients need a clear complaint and redress route. Foreign legal demands need mandatory reporting and challenge rules, and the NHS needs a tested exit plan. A contractual break clause is useful only if the data and workflows can actually be moved elsewhere. Another uncomfortable question is the United States Cloud Act. In some circumstances, a provider subject to American jurisdiction can be required to produce data within its possession, custody, or control even when that data is stored abroad. That does not prove any American authority can access this particular NHS platform. The answer depends on the contracting entity, corporate structure and actual technical control. Palantir argues foreign sovereign data is segregated. No evidence in this investigation shows an American demand for NHS platform data. The NHS contract is part of a wider government relationship. In February 2026, the NERV counted at least £670 million in current and historical UK public contracts linked to Palantir, spanning defence, policing and nuclear-related work. In June, an MP told Parliament that Palantir had at least 34 current and past contracts across at least 10 departments, worth a minimum of £900 million. That is a figure stated in Parliament, not a single independently audited government total. Cross-party Commons committee warned that the company's expanding presence created an unacceptable point of weakness. Its concern was not simply whether the software works, it was strategic dependence, sovereign control, and the risk that one supplier becomes too difficult to replace. A supplier can comply with every current instruction and still create a future national vulnerability through concentration. When the same company's software sits across health, defence, and other state functions, procurement stops being a routine purchasing decision. Palantir was founded in 2003. Its own stock market registration says its original software was built for American intelligence and counter-terrorism work. Early backing came from In-Q-Tel, the venture organization created by the CIA. That history does not prove wrongdoing. It explains the product's design, link fragmented information, manage permissions, surface relationships, and support decisions inside high-security organizations. Similar capabilities can help coordinate hospital care or support defense operations. Governance determines how those powers are used. In January 2024, after a board meeting in Tel Aviv, Palantir announced a strategic partnership with Israel's Ministry of Defense to support what the announcement called war-related missions. That wording is documented. Claims about specific strikes or products require separate evidence. In October 2024, Norwegian investor Storebrand sold a Palantir holding worth about $24 million. It cited the risk of contributing to violations of international humanitarian law and human rights in occupied Palestinian territory. That was the investor's risk assessment, not a judicial finding. In 2025, United Nations Special Rapporteur Francesca Albanese named Palantir in a report examining corporate involvement in the occupation and Gaza war. A special rapporteur is an independent mandate holder. Her report is significant evidence of scrutiny, not a court judgment. One claim must be ruled out. Reporting on the Israeli military's Lavender targeting system described tens of thousands of people flagged and a reported error rate, but no published evidence reviewed here connects Palantir to Lavender or Gospel. Palantir denies involvement with either. Thiel co-founded PayPal, became Facebook's first outside investor and built a network of funds around Founders Fund, Vala Ventures, Mithril Capital and Thiel Capital. The importance is not simply his wealth, it is the reach that wealth buys across companies and politics. Founders Fund was reported to manage around $17 billion in 2025. Forbes estimated Thiel's personal wealth at $27.9 billion in July 2026. Both figures move with valuations. They are dated estimates, not fixed amounts of cash. Political network is unusually direct. J.D. Vance worked at Mithril Capital, a Thiel-backed investment firm. Thiel-backed Vance introduced him to Donald Trump and helped finance the campaign that sent him to the United States Senate. Thiel gave $15 million to protect Ohio values, the Super PAC supporting Vance's Senate campaign. That was not a direct payment to Vance himself. Vance is now Vice President of the United States. The documented relationship illustrates political patronage, not proof of secret control. New Zealand granted Thiel citizenship in June 2011 through an exceptional circumstances provision. Officially released papers showed that he had spent only 12 days in the country. The citizenship ceremony took place at the New Zealand consulate in Santa Monica. In 2015, he bought roughly 477 acres near Lake Wanaka. He later proposed a partly earth-sheltered luxury lodge for up to 24 guests. Some described the design as bunker-like. It is essential not to mistake an architectural proposal for an existing bunker. Local authorities refused consent. An Environment Court appeal failed in 2024. The lodge was never built. A rejected hillside proposal can still tell us something about a billionaire's preferences. It cannot honestly be presented as a completed escape compound. Jeffrey Epstein invested $40 million in two Vala Ventures funds in 2015 and 2016. After his 2008 conviction, Vala later confirmed that investment. The money went into Vala funds, not into Palantir. Released schedules and files indicate a continuing relationship with Thiel into early 2019. Wired counted his name more than 2,200 times across a larger document release. That is not evidence of 2,200 direct messages, because documents can contain repeated references and scheduling traffic. The post-conviction financial and social association is newsworthy. The cited material does not establish wrongdoing by Thiel or involvement in Epstein's crimes. Reporting the evidence precisely is not protecting powerful people. It is making the investigation harder to dismiss. Before ministers extend the NHS arrangement, they should publish which privilege roles can technically view identifiable information, how many NHS and contractor accounts have held those roles, and how long each privilege session lasted. They should explain who controls encryption keys, whether each session is observed or independently audited, and what happens if a supplier or cloud subcontractor receives a foreign legal demand for data or metadata. They should publish every material change between the original and current privacy assessments, explain why contractor access was absent from the version seen by the National Data Guardian, and set out the process for correction and patient redress. Finally, they should produce a costed and rehearsed exit plan, prove that datasets and workflows can be exported, identify credible alternatives, and publish benefits that are measured independently rather than repeated from supplier claims. The NHS does not need to prove Palantir is uniquely wicked. Palantir does not get to answer a governance question with trust or controls. The issue is whether the public can independently verify what a powerful system actually permits. Who can see what? Who approved it? Who checks the logs? And if the answers change, who makes sure the public is told? This has been the Peter Thiel dossier. The evidence is on the record. The next decision belongs to the government, the NHS, and all of us.